Brazilian inheritance law for foreigners, rights, tax, and legal procedures. If you have a family, real estate, or a bank account in Brazil, there is a rule that you most foreigners discover maybe too late. Half of the inheritance doesn't automatically belong to you. And since 2026, the tax that apply to it has changed dramatically to this point that some families will pay maybe 2 or 3 times more than in the past. My name is Iure Pontes Vieira. I'm a Brazilian attorney, and in this video I will walk you through six points you need to know before a Brazilian inheritance lands on your desk, or before you organize the transfer of your own assets to Brazil. So which law applies? Brazilian foster heirs rules, the new 2026 inheritance tax, the probate procedure, and how to plan ahead before it's too late. So first point, these ones that surprise people the most, I think. Under Brazilian private international law, the law that governs a succession is, in principle, the law of deceasor's last domicile, the Brazilian statute that governs the conflict of law between countries. So the last domicile of the people who died. Okay, and you need to think about there is some exception that whatever are assets located in Brazil, courts very often apply whichever law is more favorable to surviving spouse and children. So the practical results: real estate, okay, or bank account in Brazil can end up being handled through a Brazilian probate procedure, even if the deceased had lived abroad for example, 30, 20 years and had no other remaining ties to Brazil. So this scenario I can see regularly. A foreign national who settled in Brazil years ago, married to a Brazilian spouse, for example, or children holding a dual nationality, for example. At the death, the family can end up with two parallel procedures, one for assets abroad, one for assets in Brazil, and each one applied differently, of course. So this means without coordination between 2 or 3 systems, the risk of deadlock or roast of the conflict court decision is very real. So think about the difference between Brazilian system and foreign system. Point 2. What's mean legitimate? Brazil's forced heirship rule. That's the one that caused the most anxiety, the most problem, I think. In Brazil, 50% of the estate is legally reserved for what's called necessary heirs, children, parents, and surviving spouse. You cannot disinherit these people, not even through a will. Don't forget that. And yes, you heard that right. The surviving spouse in Brazil inherits alongside the children in proportion that depends on the marital property regime chosen at the time of the marriage. So the regime of marriage, the system of property, may choose the way that you read it assets in Brazil. Okay, does not work the same way in the most common law or civil law system that you can give all your property in the will, but in Brazil is not possible. The second problem, the concept and the implication of domestic partner in Brazil called stable union. Okay, the stable union in Brazil, the rights that you have when you sign the stable union is almost the same you have as married. If you marry with someone in Brazil, you have the different rights, okay? And the federal court in Brazil, this federal Supreme Court, that said that in case of heritage, you have the same right as a spouse if you have a civil union in Brazil. Think about that, because in this case, it's really different rights from abroad. So in practice, that means that someone you may not even know about could show up and say that I'm a legitimate here to part of the Brazilian state. Of course, many Brazilian families discover that only in the end. So a will draft abroad doesn't automatically override this first heirship rule for assets located in Brazil either. This scope needs to be verified under Brazilian law, not simply assumed to apply as written. Okay, so think about, even if you have a will done abroad, you need to pass through the verification looking to Brazilian legal system. 3 points. The inheritance tax change during 2026. We have in Brazil a ITCMD is the name of the inheritance and donation tax. It is a state level tax, so you have 26 types of law, okay, included in more federal district with the own rules. That means we have rules in São Paulo, we have a different rules Minas Gerais, different other rules for Rio de Janeiro, and we have, of course, some limitation of difference between law. For example, the maximum of rate for inheritance tax in Brazil, it is 8%. 8%. You can no other state in Brazil can increase this rate. So regarding the change during 2026 that we face now, we have progressive rates that are mandatory. Okay, so they change because that used to apply flat tax like São Paulo now, and nowadays the flat tax in Brazil or in São Paulo is 4%, but now they need to change their law to use a progressive system according to, for example, the amount of the assets that someone needs to receive. Okay, and another, I think, point that is really interesting, that if you live or if you have assets outside, because taxation in Brazil of inherent, okay, involve assets or people abroad now explicitly regulated by Brazilian law. Before this reform, it was complicated. It was a Brazilian court that said it's not the Brazilian system, Brazilian law couldn't access or couldn't tax assets when it was located abroad, but now it's possible to tax. Okay. Part 4, the procedure. We have in Brazil 2 types of probate. How this work? You have 2 types. So the extrajudicial probate, in this case, is handled through a notary by means of public deed. The notary do this deed. Okay, I think it's the first one. but it's not doesn't work when is the adult is in conflict. Okay, but it's this the people make part of this probate. Once they are agree, you can go using the extrajudicial or extrajudicial probate doing by a notary. The other possibility is go to the court. Need to go to the court and apply to do the probate. When the heritage, when the people is not agree with the terms, they need to go to the court. Of course, it will take more longer to find a solution because the judge must handle your case. About the documentation that you need to have. If you make part of this, if you heritage something in Brazil, first, of course, you need the birth of certificate, okay, your birth certificate. If you have a birth certificate made abroad, you need to have a apostille, okay, and here in Brazil, you do a sworn translation, okay. So you need, for foreign documentation, need to be apostilled. And 0.5, the risk of double taxation on cross-border conflict. I think it's the last no, but just as important, because since there is no bilateral treaty between Brazil and the other countries, but of course cover inheritance, okay? And the same asset could, in theory, be taken into account for both in your home and country side, a country state declaration, okay? And another point, there is no tax rule, treaty rules between all the countries when you talk about inheritance tax, okay? So if you need to pay inheritance tax abroad or in Brazil, you couldn't use the money that you pay to deduce the amount abroad. Brazil have no tax treaty in terms of inheritance tax. So of course, when we talk about the two different systems that is not coordination automatically, it's necessary to verify each asset involved in this operation. This is something that many families only discover when filing their home country tax return, for example. Of course, you have in Brazil a tax treaty about income tax, but only with income tax. You have not with other type of taxes in Brazil. In the end, part 6, tax planning or planning instead of reaction. And that's mean that everything I've described so far concern a state, okay, that's already open or death that already occurred. Most of, I think, these difficulties can be significantly reduced through advanced planning. For example, if you have a real estate in Brazil, you can pass as an individual own this real estate, you can pass through a company. Even so, you can pass through a foreign company. So you can put this real estate, okay, change the ownership to foreign company. If you die, it's not necessary to do the probate in Brazil, not to do the system in Brazil, even not use a Brazilian system, because the ownership of the real estate, even the real estate is located in Brazil, is not passed to the change of ownership, because it's the owner of the company is died, not the owner of the real estate. Okay, so if this video was helpful, a like goes a long way in helping this kind of content, okay? And if you want to know about more subjects like tax, income tax in Brazil, open a company in Brazil, I have all the videos about those subjects. And thank you very much, and see you in the next video.